Hey out there, legal warriors. In this video, I'm going to cover the different type of protection orders and the things you need to know about what type of protection order to ask for in Washington State. Now, you might call it a restraining order, but legally in Washington State, when we ask someone to stay away from us, throw someone out of our house, stuff like that, they're called protection orders. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like, please subscribe. More people get to see it. More people get the help they need. They just heard me say, hey, I'm a criminal defense attorney. Well, we also handle protection orders, and there's two main types of attorneys that I typically see handling protection orders / restraining orders. Same thing, different words. Typically family law attorneys, because they do a lot of litigation and trial work, and criminal attorneys who do a lot of litigation and trial work. Even though it's not the subject of the video, typically speaking, many family law attorneys will charge hourly for that type of work, and many criminal attorneys will charge a flat rate. It's just because there's differences in the practice, so keep that in mind. Now, in Washington State, about 2 years ago, the legislature recodified all of the restraining / protection order laws into a single statute. And so everything you ever wanted to know, and maybe everything you didn't want to know, is in RCW 7.105 that has all of the different types of restraining orders, all of the ways you serve them, how court works, how long they can last for, what you can ask for. It's just detailed, and I carry that law with me anytime I go to court. I actually call it the hot sauce. Give me the hot sauce. You know, the hot sauce is what we need to top off our tacos, stuff like that. Well, it's what we need when we go to court too, so you want to know the law. But step one is, what are the different types of restraining orders, and which one should I ask for? Well, there's 5 or 6 different types, and I'm going to cover most of them here, the ones that you're going to want to know about. The most common type of restraining order out there in Washington State is a domestic violence restraining order. Domestic violence restraining order means that someone is alleging that they're a victim of domestic violence. Now, that someone has to have a relationship that qualifies them for a domestic violence type order, because a neighbor cannot get a domestic violence order against another neighbor, most likely because they wouldn't have the type of relationship that qualifies for a domestic violence order. So first of all, we have to think about what is the relationship between the petitioner, the person who wants the order, and the respondent, the person the petitioner is asking to restrain. And basically think about it as someone that you've dated in the past, someone that you've lived with in the past, someone that you're currently dating, currently married to, or typically a blood relative. Now, it can get more specific than that, but it needs to be someone that either you've lived with, that you're related to, that you've dated, that you've married, something like that. And if there's that relationship, the legislature has made it easier to get a protection order, because the civil definition of domestic violence under RCW 7.105 is very broad. It's much more wide and broad than criminal domestic violence. In a criminal case, domestic violence is a designator. It's not an actual crime. It designates a relationship between parties in the criminal matter as family or household members. It's pretty similar to the civil definition. However, in the criminal realm, usually domestic violence is assault or harassment, making a threat, damaging property, stuff like that. And if those things have happened to the petitioner in his or her relationship, that would qualify as domestic violence under the restraining order statute, the civil definition, but it goes way further than that. I'm not going to go word for word with what it says, but think about it this way. The law says something along the lines of, hey, if the respondent has inflicted fear of harm, that could be enough for domestic violence. So if the petitioner has suffered subjective fear of harm based upon the actions of the respondent, that is potentially and has been found to be domestic violence under the protection order statute. Furthermore, there's something called coercive control, and that's this big, long definition. It says if the respondent has done things that sort of interfere with the reasonable freedom of the petitioner, controlling where they can go, who they can see, making threats of suicide if they leave them, threatening, I'm going to get a gun, just cursing people out could be enough, controlling the finances. It's pretty broad. And so when we think about a domestic violence protection order, if you have that relationship that's a domestic violence qualified relationship between petitioner and respondent, that's the order that someone's going to want to ask for, because it gives the most broad definition and the easiest way for the court to grant the protection that the petitioner wants. What I tend to say is, hey, garlic breath may be enough to give someone a protection order because it's just that broad. Now that's, it's not exactly that, but that's what it feels like because it's so subjective. The respondent could not mean anything by some comment. The petitioner could be just as mean back to the respondent, but it's not a balancing contest. The court is not looking at who's more in the right or who's more in the wrong. Whoever is the petitioner, they get to say what happened to them. The respondent doesn't get to defend by saying, but the petitioner did it to me. So if a respondent gets served with a domestic violence protection order and they also feel they're a victim of domestic violence, the most rational thing for the respondent to do is go file for their own protection order. Go try to get your own protection order against the petitioner. That way, maybe each party has an order, and at the permanent hearing now, maybe it is more of a balancing contest. So that's the first and most common type of protection order. The next one is called an anti-harassment order, a protection from unlawful harassment. And that is for pretty much everybody else. If there's not a domestic violence relationship qualifying relationship between the parties, not dated, not related, stuff like that, then like neighbors, strangers, co-workers, they would file typically for an anti-harassment or an unlawful harassment protection order. So think about that is that the definition of that says, hey, the petitioner is claiming that the respondent is engaged in a course of conduct, that means a series of acts that show a continuity of purpose, no matter over how short of a time, but they've engaged in a course of conduct that is designed to and actually does cause substantial emotional distress to the petitioner, the person asking for the order, and also that a reasonable person would also suffer substantial emotional distress. And that course of conduct needs to not be for a legitimate or lawful purpose. And that's also defined in the statute. When the court looks at whether or not a course of conduct is legitimate, because guess what? We could do legitimate things and if it causes someone to be upset, so what, right? So if what we're doing is a legitimate course of conduct as defined under the statute, then that would not be actionable. And so the court sort of does a weighing test when they look at whether or not the course of conduct being complained of by the petitioner that's claiming that the respondent's conduct is causing the petitioner substantial emotional distress. They say, well, is what the respondent's doing fit within a lawful course of conduct? And what the court looks at is, hey, are both parties communicating? Is the petitioner also communicating to the respondent and the respondent's just responding to the communication? Has the petitioner put the respondent on clear notice that no contact is wanted? And also, is the respondent, are they acting pursuant to any statutory right to protect a liberty interest, to protect a property interest, right? If someone's crossing your lawn, get off of my lawn, would probably not be harassment because you have the right, if it's your lawn, to tell someone to get off of your lawn. If it's, get off of my lawn or I'm going to shoot you, well, maybe not, right? Then it becomes more of a question, is that harassment, is that a threat? But so when we see someone filing for an anti-harassment protection order, an unlawful harassment protection order, usually what we see is notice to the respondent that no contact was wanted, and this continued hounding of the petitioner. Text messages, phone calls, threats made in messages. Sometimes it's a dispute over money. We see things like that. And in this case, the court is trying to decide whether or not the petitioner can prove by a preponderance of the evidence, is it more likely than not, that the respondent has engaged in that purposeful course of conduct designed to cause the petitioner substantial emotional distress, needs to be directed at them directly, not just the public in general, and that a reasonable person would suffer that distress. So if you're looking for an order and they're not related to you, if it doesn't qualify for a DV order, that's the most likely type of order you're going to ask for. That's unless we go to the third type of order. I'm going to call it an SA order. You can probably guess what that is, but YouTube doesn't like us to say those words. Typically, an SA order means that someone has been a victim of a very serious crime, some type of a sexual-based crime, and then there's an order that you can ask for that says, I'm a victim of this type of crime. Court, please protect me from this person ever contacting me again. And those cases are a little different. Sometimes there is a relationship already that qualifies for a domestic violence relationship. You're going to want to talk to your attorney strategy-wise. Do you want to file a domestic violence order or an SA order? The law says if there's a prior domestic violence qualifying relationship, you should file a domestic violence order, but you're not required to. And sometimes we think it's good to file the domestic violence-based order to get broader possible definitions, but sometimes we want to file the SA order because it's a more powerful sounding order, and an SA order has to be heard in front of a judge who's an elected official versus a commissioner who's just someone who's appointed by the judge. And so it's a really important strategy decision that you should talk with an attorney about. Now, the final two types of orders I want to cover are much less common, and so I'm just going to sort of briefly go over what they are. There's something called an extreme risk protection order, and that would be for when, sort of like the red flag laws out there, hey, we think someone is going to do something bad to themselves or to someone else with a gun, and we want to try to take their guns away. And oftentimes those are initiated by the police or by governmental agencies. It's not common that a civilian would initiate that actual order themselves, although it can happen. And then finally, there's something called a vulnerable adult, hard word to say, protection order. And think about that is, hey, your parent or somebody has been suffering undue influence from another person. Could be another family member, could be someone helping them. They're taking their money from them, they're isolating them from their family. Basically, there's some type of either financial or freedom-based abuse of the elderly person or the person who is just defined in a certain way under the statute that they're not able to take care of themselves. There could also be some other issues where they're unable to take care of themselves, and you're going to step in from them to say they need protection from the person that you think is exploiting them or otherwise abusing them. And that's a pretty complicated area. If you think you have someone going through that, you definitely should consider talking to an attorney to see should other law enforcement agencies be involved. Should there be adult protective services involved? Do we need to have other law enforcement involved? But that's something you want to think about. So remember, no matter what type of order you ask for, you can't really get it wrong. But I want you to know which one you are asking for so you think about what proof you need. The court is authorized under the statute. Even if you ask for a harassment order, if they think it qualifies for domestic violence, they can issue domestic violence. If you ask for an SA order and they think it doesn't qualify for that, but it qualifies for something else, they can issue that order. So it used to be before the law changed, if you asked for the wrong one, you were out of luck, you could lose. So now if you ask for the wrong one, the court can issue any order it sees fit. So most importantly, if you need an order or you've been served with an order, get some legal help. We do that type of work. If you're interested in talking to us, feel free to give us a call. We've been doing this for more than 20 years. And if we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.